Good evening, all the participants and the guest. On behalf of Satyabama Institution Innovation Council and Department of Information Technology, together we are organizing this webinar on intellectual property rights. So, with the support and the platform given by MHRD and AIC, Institution Innovation Council IIC, we are organizing this program for the benefit of the students. The students are from engineering departments. This is not a technical program, but being an engineer, they should aware of intellectual property rights. So I welcome all the participants, guests, and the faculty coordinator, Dr. Ajita from Department of IT for this webinar. I would like to welcome the guest of honor today, Ms. Sinduja. Ma'am is an examiner on trademarks and GI, Government of India, Trademarks Registry, Intellectual Property India, Gindi Campus, Chennai. Welcome you, ma'am, for this webinar. So she is passionate in intellectual property rights. It is need of the hour. Why we are arranging these kind of events means the government, institution, everywhere you are encouraging the students to convert into entrepreneurs. They need to develop products. They need to commercialize. They need to do startups. That is the main motto behind the government, central government, state government, and the universities. By keeping this in perspective, just to create an awareness, this is no way related to a technical, but being an engineering student, even from first year, if you are aware of it, definitely you can bring it your future scope. Whatever you have learned in the technology in these 4 years, you can take it to some other level. You can map the things, whatever today we are going to discuss. Ma'am is just going to give an overview about all the basics of IPR. So it is a new term, I guess. Intellectual property rights means it is a new term for you people, I know. But ma'am will be clearly explaining you what are all the components coming under intellectual property rights, how you can develop the product, how you can commercialize it, what are all the benefits you are going to get. So I think this will be very informative to you. Once again, I welcome you all for this event. Now over to ma'am. I request ma'am to start the presentation.
Thank you, ma'am, for a brief introduction about me. And as ma'am said already about the session, is my voice audible, ma'am?
Yes, ma'am. It's
Can you
audible.
proceed? Okay. So as already given brief introduction by you, this is not a technical or legal session today, because IPR means it's a legal's professional budding area. So in what way is this IPR connected to the engineering professions for the present and the future is what we are going to see today. So first, let's understand the word IPR. IPR, it means that intellectual property rights. Before getting into the technicalities, first let's understand what is intellectual property. We all know what is a property. So property is nothing but any physical asset that we have with us in whatever form, whether it's mobile, immobile, whatever. And now it is time that we have to understand what is an intellectual property in this digital era, which is what we are today dealing with. Even this presently, this seminar also is nothing but it's one of the someone's a patent that we are using today, with having several components right from the system to software in it. You guys must be more aware of it. And now coming to the introduction part of the IPR, what are the, there are so many different forms of IPR which we will be dealing in the subsequent time. First of all, whichever form of IPR, every IPR is basically a brainchild. So, see, it would be anything, either a patent, trademark, copyright, design, whatever it is a brainchild. So that is which is an outcome of your thought process. And it should have certain unique qualities in that to qualify itself to be called as an IPR. Okay, so here we can see, today we would be discussing the different forms of IPR, and I have mentioned that only expressions can be protected. What is this? Only expressions can be protected. See, we all would be dreaming of having a chair like that. Why can't it just move like that? So we may have some ideas in our mind for several days. Can that be protected is a question. No, certainly not. Any idea that you have, it should be reduced to a tangible form. So now we should understand a new terminology called intangible medium. What is this intangible medium? That's something that we cannot really see or feel it, but you can only, it is in the imagination. So ideas cannot be protected. It has to be expressed in a medium that it can be reproduced for further use. And then intangible property. As I said, these physical properties or tangible properties. So intangible property which are lacking physical component in existence, and then transferable, of course, because if certain IPRs can be transferred, you would have seen in several movies where it is transferred, the patent rights have been transferred from one company to another company, and then the patent is transferred to the
Ma'am, voice not audible.
Muted your.
Ah. Ma'am, unmute, unmute. Slideshow.
would you please mind
Okay, no
sharing this?
problem. No problem. You continue, ma'am. Continue.
Okay. So starting with the different types of this IPR, we have this patents, then designs. Usually patents and designs go hand in hand. And then the trademark, copyright, and geographical indications and plant variety protection. Don't think these are the only types of IPRs that we have. There are many more, but these are some of the important things that we must know when you should know what is an IPR. Dealing with these patents, what are these patents? What would you call as a patent? You can see from this next slide that something that you really invented, not discovered, right? So it has to qualify certain characteristics, starting from that it is a novel and new, that is, it does not exist prior in the market. You would have heard about the term prior art. There may be a prior art. If there is a prior art about the same product, there has to be an inventive step, real development in that. And there is a word called industrial utility. Just like that, you cannot see that say that you have invented something really new, but it cannot be called as a valid patent unless it serves an industrial utility solution like that. And then of course any of the IP, some of there are certain qualities that has to be in common for all the IPRs like that. It also says that it should not be opposed to public policy, especially like a country like India where it's certain things are reserved here. Right from patents to all the things, we have something reserved. So and in that reservation we have that it should not be opposed to public policy. And then transferable asset. When I say transferable asset, just like any other asset, it can be transferred from one owner to another owner, wherein with legal documentation, a contract would be signed between them, what are the rights, for how long, or to what extent he can use and all that. And then compulsory licensing. What is this compulsory licensing? You may see, for example, in the present situation, someone would come out with a solution for a vaccine, even for the COVID situation. So he cannot own a patent on that because it has to serve a larger utility for the public. So those cases are compulsory licensing, and also in some cases where it is threatening to the public at large, there also the government would make him to compulsorily surrender it to the government for inventions like related to atom bomb. Those things cannot be held with a private person. So there are some limitations in owning a patent also. And then limited period. Usually when a patent is granted, it is given for a period of 20 years, after which it would be entering the public domain. And then here in patents, since I was told that the present participants are from the IT field, in what way this patent you have to concentrate is that, for example, when you work for a company, you come out with a design, and that design, and do you think you can claim an ownership over that? Certainly not, unless otherwise there is a private contract between you and the company. You cannot claim patent over it. For example, you work under Wipro or TCS or CTS, where you come out with a programming or research or something, because the company is funding you. So in those cases, all the patents would be lying only with the company, not with individual persons. So anyhow, even though you produce it or you invent it, it would be under the head of the ownership or the proprietorship of the company. So these are the things that you should know as an engineering professional when you talk about patent. So in what condition you are eligible to it. And there are situations wherein you would be working under a company and suddenly all of a sudden you might just walk out, and with that labor and research, when you come out and do it also, so there comes some litigations on it. So these are all the issues that you have to concentrate when you talk about patents, because you may say that you have really invented it, but under the sponsorship or funding of a major organization. So in those cases, who would be owning that patentship? So this is what you have to know. So regarding that, this is just an ventilation that I'm giving you into the IPR. So once you understand what is an IPR, now you understand what is basically a patent. So basically a new invention which has some a solution to a major problem. So those things are called as patents, and the area that you have to focus being in the IT field. And then coming to the copyright. Next to copyright, and now the question arises, can software be patented or copyright? That is a major area that you have to concentrate. So for that, beginning we should know what is a copyright. You might have several books with you. You would have seen that there is a small c within written within a small circle, which is copyright protected. And first of all, we should know one more thing also, is that whenever a work of copyright is done, it is automatically being protected. So registration is not necessary, though registration of a copyright is mandated for the reason of a strong foundation for a legal battle in future. That's it. So you can see some of the pictures here that I've given. So copyrights are basically literary works, and in generally itself you can split the IPR into two groups, that is literary and industrial. So this industrial would take up patent in its control. So this copyright would come under this literary works. It has to be original in nature. That is the most important criteria whenever we talk about this copyrights. You can see the first picture where some books are kept. So it means that it's original authorship of a particular person where he can claim copyright. And then musical works, those compositions, and a particular picture I have given here. Why? Because there are some movies which are adapted works. This is a classic example of it, wherein a novel by Mr. Chetan Bhagat is being translated, is being adapted by a film director and then given a new shape as a film. So this is an example of an adaptive work. There are many things. I have just culled out the important things. You can see what are all the different works that have been covered by the copyright. So it basic copyright mainly subsists in the works of original, that is very important. Original works of literary, that is authorship, then dramatic, which even includes performers right recently, and then musical rights, cinematographic, sound recording, works of adaptation. That's what I said, adaptation of a novel to a new film. You may think that these are all only in the books, but every day we can see these problems right from the courts, either high court or supreme court, saying that some of the directors and script writers, they may say that he has taken up my script, or he has taken up my lyrics or something like that. Even a few years back there was a problem between the musician Mr. Ilayaraja, that he had sent a legal, it's all very famous. So these are some of the issues, because copyright mainly involves two main things, that is royal rights, moral rights, and economic rights. So economic rights, we can understand what it is. Economic in the sense that he would be getting a royalty, that financial benefit out of it, which is nothing but called as the economic benefit out of it. And especially copyright, there is a component attached to it called as the moral rights. And moral rights can be attributed only to copyright. No other copyright has these moral rights attached to it, because copyright is given a higher status of literary works. So wherein moral right is considered as a major right, wherein it shall not be diluted by these things. And you may ask, okay, even today you may be taking several copies of your books, this that, for your assignments, exams, this that and all, but that is an exemption given. So for the purpose of education and giving a lecture or anything, we can take that. So in that case, it doesn't amount to plagiarism. So when you don't earn anything commercially out of it, or if it is purely for an educational research purpose or to understand and to disseminate the knowledge, so in that case, it does not amount to plagiarism, and it is purely exempted from the violations of the Copyright Act. And then coming to trademarks. Trademarks again is a very vast and very interesting portion also, because today the trademarks has grown up to a higher level that it can even include sound trademarks also. You can no one of us can forget the roaring sound of Tom and Jerry, which starts before the cartoon actually. So which comes for 9 to 15 seconds. So that was one of the first few sound trademarks that was actually given. So like that, even that Google sound, Yahoo sound, even they have all sound trademarks. So first understand, so I have told you what are some of the trademarks. Now let's see what is a trademark. Okay, fine. You have come out with a good invention. You have come out with a good book or anything, but you have to name it, just like naming a small baby or something. So you have to name your product what it is, because without naming a product you cannot sell it in the market. So what is it? Branding. So particular name. So with the trademark, a person in the market as a consumer is able to identify the consumer of the producer, sorry, the producer of a particular product, with which he can associate these certain qualities and characteristics of a product. So that is the whole purpose of a trademark. Because with some trademark, you need not worry about the, because if you hear the name, you need not worry about the quality or the warranty or whatever it is. It would be taken care, and you know the reputation or the better reputation of the company in the present market. So that is what is trademark. So trademarks can be in different forms. As I said, a sound trademark is a very recent development. Since 2017 we have in India. So now some sound trademarks are also being registered nowadays. And then in recent treaty by the Singapore Treaty, even smell is being included in a trademark. So it would be coming in the uh, coming decades, where in India will also be a party to which we have smell as a trademark. Now, to what are the trademarks that we already have? We have some of the forms basically form as word trademark. That means you have a shop or you have your product or software, you can just simply name it. So that is a word trademark. Or you can see some of the designs on the screen. There are some logos of a particular, if you see the first thing itself, you can identify it's Apple brand. So you need not worry about the branding in it. So the quality or characteristics of a particular product. So these are all the different trademarks that you have. And then the next slide, it says that invented or coined word. What is this invented? Again, what is the connection between invention with trademark? Whenever you name a thing, name a product or service or anything, the best way that you can claim a trademark is that by inventing a coining a word, whether it has meaning or better that it doesn't have any meaning. That is the best thing. So the first level, the very first characteristic of trademark should be, it should be coined word, that you put some random words. So it doesn't mean that you have to put like words like that you cannot spell, like starting with Y, X, Z, something you cannot even spell. Not like that. You have to spell it, but in such a way that it does not have regular usage in the everydays. For example, words like yeah, of course, why not, these words cannot be good, because there is no uniqueness in it. What is this uniqueness? It shall not be in the general usage, in the everyday usage. That is very important. And then some of the trademarks can be very suggestive. Sometimes it may be suggestive, but the best way of branding is it is really invented or coined. And then suggestive marks. And there are some limitations also, like just how we saw in patent. I'm just comparing side by side. In patents, I said that there are certain limitations, like it should not be opposed to public policy, or it should not be a threat to public at large, or it should be, if it is of greater help, like life-saving medicines or anything, it shall be taken up by the government. So either it would be rejected or it would be acquired by the government. Like that, in trademark also, there are certain rules and regulations to accept and to reject a trademark also. And here you can see a chart The chart says the overall filing of a trademark. So wherein and today's anyone can file a trademark, not necessarily that only through an advocate, because even for a patent it needs a lot of work like specification. In patent filing, specification involves major time in it. You should know to give how to file a patent, that is giving by specification and like that. But for a trademark it is very easy. If you're having your own business, you can just name it and you can directly file for a trademark. It is very as easy as you can see. You just have to give the details properly, and please don't give any don't leave out any supporting claims in that. If you say that you have been using the trademark for the last 3 years, please, if you mention it, please provide documents for it. And then if it is a partnership, if two persons, you give all your details. And if it is a company incorporated, give those details. So whatever you are asking, for every word you say, you just support your claim. That is what is very important. Otherwise it would be leading to unnecessary delay, which is not a pleasant one. And then there are same thing even in the patent. When you don't support anything, unnecessarily uh, objections would be raised against you, and you have to respond to it. So here the problem arises when any compliance is not done properly by the students, by the people who are filing it or who are coming for the procedure, that is for the hearing or whatever. So here two words you can see, new that shokas hearing or opposition. This shokas means some preliminary objections wherein you are asked to answer for it, and there is opposition. In opposition, it means that whenever a trademark is accepted by the office, it would be published and it would be in the public domain for a period of 4 months. So at that time, anyone can question you, anyone can file an opposition, and you should be in a position that you have to overcome that opposition to win your trademark. So this is a very simple process that you can see. So the one thing I have to say that is that whatever you claim, you please support all your claims with the necessary documentations. That's it. So this is about trademark. And this trademark is for a period, and also it is transferable. You can transfer your trademark at any time. And then relating to the period of protection, the period of protection is usually given for a period of 10 years, and at the end of 10 years you can renew it for another 10 years, and it is continuously you can have the trademark with you, not like the patent, which is only for 20 years. And with the trademark, see, once it is not renewed, there are certain fines that you have to pay, wherein to make your trademark to come into validity picture. So that is all about trademark. And then just like the trademark, we have the other things. Similar to trademark, there is one more branding of certain products called as the geographical indications. What is the difference between geographical indications and, because they're just like I said, patents and designs go hand in hand, and here also trademarks and geographical indications are very close similar, because both are branding. But the only difference between the trademark and the geographical indication is that anyone can have a trademark, but a geographical indication is given not to an individual person, but it is given to a group of users, authorized users who are affiliated to that particular community. So here you can see the map of India indicating certain names originating from certain cities, particular cities. So you would have heard in subsequent slides, you can see the names of certain products. So with that, you can understand what is it. And then it is not for an individual user. So what is the subject matter of protection? So till now we saw that in patent it is a particular new invented product which is subject matter of protection. And then in copyright it is a literary or dramatic work which is a subject matter of protection. In trademark we saw the logo or the brand name which is the subject matter of protection. Here the goods are the subject matter of protection along with its name. For example, if I say that it is, if we want to buy certain things, and without our knowledge we used to say with the name of that particular city, I want the product from that particular place, because that particular place has its own influence, climatic and geographical influence over the characteristics of that particular product. So here you can see agriculture goods. If you see the subsequent slide, you can see so many products in that. Agriculture goods, natural goods, manufactured goods, handicrafts, including handloom, industrial goods you can see, even wet grinders, which are good inventions. They are, when we say it's Coimbatore wet grinder or something like that, it is known for the particular place from where it comes. And then foodstuffs, of course, Tirupati laddu we cannot forget it. So when you hear that GI name, you are very sure about the quality. So that is what the whole purpose of it. Whenever a particular product is given with this GI protection with its logo, right now there is a logo framed by the ministry. So with that logo and other accreditations, when the GI product goes for an international market, you can see the demand for it, or the quality for which the demand would be higher. Then, as I said, there are different types of geographical indications also. Some are direct GIs and some are indirect GIs, which may not have the name. Only the variety is given as a geographical name. You can see the first two wherein the names of the particular place are attached to that product. So with which you know that it is a sure product from that quality where it is assured. In Kanjipuram Pattu, you may ask, because what is the speciality of the geographical condition influencing the dress materials or whatever? There it includes the skills of the laborers that who are managed, because for generations they have that particular skill, and with till what temperature of water, or till what. So their labor also involves. So basically this IPR, they revolve on a theory called John Locke's labor theory. So this labor theory is very important whenever we talk with this IPR, right from the patent to GI. We should have some invested amount of labor in it. Without labor, no GI, no IPR is appreciated. You can see. And just like we saw some of the prohibitions or limitations in patents, trademarks also, here some of the prohibitions for GI. On comparison with the trademark, for example, can anyone try to trademark a national emblem or anything like that? No, because it is again prohibited under certain rules by the legislations. So here you can see some list of items which are restricted from filing of GI. And this is the main difference between the GI and the trademark. That is, in trademark, it is given to any person coming with a new logo or anything. But this GI is given to a person, to a group of users. So authorized users, so they have to form a part of that association to claim themselves as a registered user. Otherwise, they cannot claim any right in that product, because it shall not be diluted, the quality shall not be diluted. So just like that, a GI is not given, it is being analyzed and estimated by a team of experts, and then only a GI is given. So those qualities shall not be diluted by any external person. So for that reason, he has to be involved in the association of persons. Then only he would be given that authorized user, and then he is a part of user of that GI. And then here you can see some of the products, right from Kashmir to Kanyakumari. We have several products of GI, wherein you have to understand the qualities. And so this place is very much famous for this particular product. So these are all the GIs and different forms. And one more thing I have mentioned about the plant variety protection. Plant variety protection means there are two famous cases that we have to know is regarding turmeric and neem, wherein before we have this we had this protection for neem and turmeric. Our neem and turmeric were patented by the US, wherein after that India had a long battle fight with the US government, and they were made to revoke their patents on neem and patent, and India came out with a solution called as the digital library. That is traditional knowledge digital library. What is this? So depending upon, and how we won the battle was with the help of some Vedic literature that we had, where it was written regarding the usage of neem, turmeric and all as medicines in Ayurvedic field. So they were all the literature available for us. to regain our own ancient practices. So with that, today we have a traditional knowledge digital library wherein all these ancient producers are being digitalized for further knowledge and those things. So it's still, we can say that IPR is not, you cannot confine IPR to anything, only this or that. IPR is everywhere and it has its own way of protection. And even in trademark, you can say whether it is compulsory to register your trademark. No, again, it is not mandatory. If you register your trademark, when there is a fight between you and the opponent, you have a valid title over it, that you have a very legal front in it. That's the difference. Otherwise, different remedies you can get, that is different types of solution you may get, according, not putting it technically, different types of solution depending upon your status, whether you have registered or not. Even if you're not registered, we have the general way of protection. If you are registered, means you have the, in IPR way, what is the solution given to you, whether the accounts to be given to you or the compensation given to you. That is common for everything, right from patents to GA. So whenever there is a violation, or there is a copy, or there is any duplication of any product, so for those cases some legal battles may go on. So in that cases, we should be very correct in budgeting, that is pricing our products, because some people, what they do when they transfer their IP asset, so it is nothing but an IP, intellectual property asset. So when we know about the other asset, these are intangible assets or IP assets. So what they do, they just undervalue the asset, and then it would be going on for stamp papers. So in order to reduce the stamp value, what they do, they undervalue their business or the branding name or the product's value. So this would have an adverse effect when there is an outcome from the court verdict, because this is the value, so they would give you very less compensation for you. So it is always better to have a good valuation and analysis of the product, depending upon the cost of investment and everything associated to that, which is common for all the IPs. So whenever there is a transfer or anything, so it is a must that a proper analysis should be given with proper reputation. So these are the basic things about the IPR. So it is an ocean. So with this understanding of what is an IPR, it just a peeping window to the world of IPR. So as the madam started saying that you're totally new to IPR. So now we all know that what is an IPR. It is nothing but a product of your brainchild, right from patent to GI. It is a product only. So of your thought process. So you think something, you innovate something, you have an idea, and you come out with a better way of expression in any medium so far that you can plan for that product, and then you brand it. So for one, you can also say that for one particular product, there are so many IPs attached to it. You have a mobile, yes, the mobile itself is a patent. It has a patent on its own for its working. And then you can say that the mobile has a name. Yes, that name comes under the trademark. And then the mobile has a user manual that is covered by the copyright. And you can see that software embedded, that here comes the concept of embedded software, where some particular for examples like products like washing machine, you have embedded software. So that is again, whether the question arises whether it is to be patented or to be to be copyrighted. So these are all the issues that you have to know whenever you invent a thing and when you go for a patent filing. So people with engineering background, it is also a good opportunity to learn what is patent filing. There is an ample of opportunities for this generation to know, to understand about patent filing, and to become a patent specification, that filing agent also you can become. And from the other side also, there are many avenues and departments and different wings depending upon the specializations that you have. So being IT field, you have the scope in the field of filing patent of specifications in the field of softwares. So these are the things that you should know. And I hope I made my points clear, and you're having a basic idea of what is an IPR. And with this basic understanding, you can understand the other components of IPR and understand much better. If there is any clarification, please let me know.
If any one of you having any doubts, means you can ask your queries. Ma'am is from the government institution, So, okay, thank you very much, madam, for your wonderful overview about intellectual property rights. I think the students might be very new for this, I guess. So, intellectual property rights means it covers patenting, then trademarks, then there's
Copyrights and
geographical indications, all these things. So in this, being an engineering student, you can develop the product, then with that you can file the patent. In terms of patent, if you are relating your software coding with some hardware component, kind of IoT device, Internet of Things, sensors, so if you integrate your software coding with the hardware device, then only you can file the patent. In US and all, for they are giving patent for software coding also. Then one more example, ma'am told, few people are raising their hand. Definitely, I'll give the chance to you to interact with ma'am. No doubt in that. Before that, I wish to share few points to you. I expected all IT students to join in this. This is very informative to you, but only few people have joined. I'm really worried about this. So no problem. Just you can pass this information to your friends also. So if you file the patent means, ma'am has given an example like mobile phone. If you take iPhone or Samsung phone, behind that technology, so many thousands of patents have filed under that particular mobile phone. So how many mobile phones coming in the market? See the ratio. So for each and every piece of mobile phone coming in the market, so who are all involved in that patent, that idea? All these people are getting revenue from that. So for each piece, a share of it was some 20 percentage of the share will be going to the particular patented who has patented the idea. That idea
royalty, we
they,
call it.
yes, sir, that royalty. So they are identifying their uniqueness, novelty, and giving that idea. No, for that they are patenting that royalty. Along that they are giving that to the company. So the company people are manufacturing it and giving the share to the people. So this patent, once you file, it will be valid for 20 years. You can make money out of it. So for all these things, from student level itself, from second year, even from first year itself, you can think about the novel things. Novel means it is not a rocket science. Basic small modification from the existing one. It will benefit to the people cost wise, performance wise means you can go for patenting. For that, government is also supporting, institutions are also supporting. Recently also I attended one recent startup contest. So in that contest, every month they are conducting. So if idea is there, most of the students in various colleges, they are presenting the idea. They will validate your idea. If your idea is good, means all the government organizations, the US people from funding, US foreign countries, all of that organizations are ready to fund crores of money to the inventors. They're encouraging the startup culture. It is not like that in olden days only. After finishing 4 years, you need to start a business. You need to gain experience in industry. After 10 years of industry experience, then only you can do startup like that. But nowadays, it is not like that. In the student age itself, you could be able to think about startups, product development, commercialization, all those things. For all those things, this IPR is the base. Patenting is the base. If you are interested in drawing artistic work means, you can go for trademarks and all. I guess it is just 500 only for registration, right ma'am?
No, ma'am, it is 5,000 for startups, as you said, or for individual person. Usually
But
it is 10,000
for
for
trademarks ma'am?
5,000, ma'am. 10,000 for companies, for limited liabilities companies, it is 10,000. If it is going to be filed in a particular my name, just my name as a single firm, as an entrepreneur, it is 5,000, ma'am. That is what is the, as you said, some economic concessions are given for
Okay.
startups. If they have to come out with MSME certificates, even if it is a corporate company, if they are startup, so small medium enterprises, financial concession is given for the 5,000 concession is given, so it's only 5,000.
So trademarks and all, thank you ma'am. Trademarks and all valid for 60 years. You'll be having that royalty for your innovation, drawing, poet, lyrics, all those things and all.
For,
So
sorry ma'am, for copyright you're saying?
yes ma'am.
No, for copyright is lifetime plus 60 years, ma'am. So if
Lifetime plus.
lifetime plus 60 years, sorry, I just
Trade
missed
for
it.
trademarks ma'am.
It cannot come to public domain, ma'am. So once you keep paying the renewal fee, you can keep it as your family property or personal. From generation to generation it moves on. It is
Okay.
only the patents and trademark that comes into public domain. For with respect to copyright, it is lifetime of that person who created it with 60 years.
Okay, okay. Thank you, ma'am. Thank you. So you think about your passion, whether you are interested in product development, you have to go for patenting. If you are interested in writing poems, lyrics, art, drawing means you can go for software coding, you can go for copyrights. Then artistic work means you can go for that logo design, all those things means you can go for trademarks. Then another thing is geographical indications.
Yeah.
According to the location, you can go.
Yeah, one more point, ma'am. Interestingly, this Walt Disney's Mickey Mouse that we all know, which is very famous, that would be entering the public domain in 23, I guess.
Okay.
So actually, there is a lot of politics in that. See, whenever that copyright law was enacted, so whenever that copyright Walt Disney's period was getting over, the law itself was amended to increase the time of the protection. So there are so many intricacies in that. So that is what the beauty of a copyright law. It was not very rigid. So when it was about to enter the public domain, the law itself was amended in such a way that it does not enter the public domain for several days. So now it is, as of now, we are expecting that Walt Disney's Mickey Mouse to enter public domain by 2023 now. Because recently I was working on for some trademark in that Mickey Mouse, so I came to know that it would be entering in 23 now.
Okay. It's new information for us also.
These are all the interesting things, ma'am. Though you may see it, however, but it's very interesting to see some of these things.
Okay. Any queries from the participant students? If you have any queries, you can raise. Akhil, Neeraj, I can unmute you, you can talk. Akhil?
Participants fill the feedback form. It is there in the chat window.
I can
Okay, sir.
unmute you. If you raise your hands means I can unmute you. In the meantime, you can fill the feedback form also. Okay, thank you, ma'am. Thank you all for your response. One of the student has raised a query from the first year. Copyright applicable world or inside country? You can post your queries in the chat window also, no issues.
Basically, copyrights is for the content. If it is a word, it comes under this trademark itself. And whether it's, see, if it is the object of the trade or subject of the trade. For example, if you have a word, if you have the word Samsung, what is it? Is it any content? No, it is only a word which you can.
Ma'am, his question is whether the recognition is worldwide or within the country.
That is what, see, when you apply, there is international filing also. With respect to trademark, I can tell you there is a Madrid way of filing, international filing, and in patent there is a PCT, patent cooperative treaty, wherein you can opt the countries that you want protection. So likewise, for all the IPs, you have to select these countries where you want to get your IP protected. Now it is all systemized and analyzed in such a way that we can select the countries and pay accordingly for the because see, for example, whenever an application comes, it has to be analyzed according to the rules and regulations of that particular country. So it's a different process now.
Oh. Any other queries? Okay, okay. Thank you, ma'am. Thank you all. I thank the Satyabama Institution Innovation Council and MHRD AICT for their support in encouraging these kinds of seminars. And also I thank the exam chief guest or Sindhuja. Instead of Chinnaraju sir, immediately you have accepted our request and you have done the very good presentation. Thank you, ma'am. Thank you all the participants. Thank you the organizer, Dr. Ajita ma'am for this event. Thank you all.
Thank you.